Hello everyone. Today we will be studying about the sources of jurisprudence. Earlier we have studied about many jurists and what they have to say on law and jurisprudence. So let's start the class without wasting our time. So the sources of law can be divided into two parts, material sources and formal sources. So what is the difference between formal sources and material sources? Let's look into it. Formal sources and material sources. Formal sources have legal implications, whereas material sources can be further subdivided into legal as well as historical sources. So, legal sources can be again subdivided into national as well as international sources. So, what the jurists we are studying are not only based on in India, they are also based of UK as well as USA. So the jurisprudence is of international nature, which we are studying now. So national jurisprudence and international jurisprudence. National jurisprudence, the sources of jurisprudence from national jurisprudence can be legislations, which include statutes, customs, precedents, general principles, as well as conventional, legal, local, and general customs and jurisprudence. So now we will see that legislation can be of two types, primary legislation as well as delegated legislation. Delegated legislation can also be said as secondary legislation. So, and customs are divided into two parts, conventional customs and legal customs. So what is the difference between legal custom and conventional custom? Conventional customs are the customs which are followed between two parties. So they are valid between two parties. But legal customs are the customs which can be general as well as local. So they can be followed all throughout the country, or they can be specific to a particular area or particular set of people. So in international sources of law, we can look into customary principles as well as treaties, conventions, agreements, which give rise to the sources of law which we will be studying. But in this net JRF, we will be concentrating more on national sources of jurisprudence. So now let's look into the first source of jurisprudence, which is custom. So customs are of two types, customs with sanctions and customs without sanctions. Customs with sanction can be further divided into legal customs as well as conventional customs. But have you ever wondered why are we studying sources of jurisprudence? Because in earlier class we have studied about the jurists and what they have to tell about law as well as jurisprudence. So that there is a need. And what's the need? The need is that we have to study not only the jurists but the law which is in force now. What are the statutes? What are the customs which are prevailing now? And have those customs changed into law? Thus, jurisprudence and sources of jurisprudence are not only limited to what jurists have to say. It is a broad idea. It includes many views. So that's why we are studying sources of jurisprudence. Now, let's look into the opinion of customs. There are two opinions on customs. One is analytical school and second is of historical school. So, do you remember the founder of analytical school, which I have taught you in the recent class? It is John Austin. So, what John Austin has to say about custom. John Austin's idea is command of the sovereign, which means that according to John Austin, when a sovereign commands us to do something, we have to do this. We don't have any analogy as to why he has commanded or what could be the better law. The law which is there in front of us is what we have to follow according to John Austin. So what Austin has to say regarding sources of jurisprudence. Law cannot be a habit unless it is adopted by law. Law gets its content from habit and popularity. He says that law gets its content from habit and popularity, but that doesn't mean that all habits are can be treated as law or can be treated as sources of jurisprudence. According to him, only the habit or only the popularity of the habit which can be regarded as law can be that which has attained a command of the guiding body, that is a sovereign, which can be a state or a legislature like parliament which makes the law, or legislative bodies like state legislature. So according to John Austin, law cannot be habit unless it is adopted by law. So it is necessary that it has a legal implication according to John Austin. Now, essentials of customs. There are various essentials of customs which we will be studying now. So when custom flows comes in your mind, what do you think? For example, let us say that there are many festivals which you will be celebrating nowadays, like Ganesh Chaturthi. So why do you think that in every occasion, whether it is marriage occasion or some ceremonial occasion, then why Ganeshi is worshipped before the event? It is because it is a custom. It has become a custom for so long that all of us are following the same custom. All the families are following the same. So the continuity of habit has made it into a custom. Similarly, like for example, we can take example of Ganesh. And second example we can take of custom is of marriages, like opening sleepers before temples. So you might have observed that whenever you go to a temple, you open your slippers and then go into the temple. So what's the need of opening the slippers? Nobody has told you to open that, and you are not punished for the same if you do not open the slippers in front of the temple. So if a custom is made, there is some reason for making it. So if we go into the past, we can say that yes, there was a reason, because in past the temples and the idols were situated much below the ground, and when the people go to the temple, they usually used to do very menial jobs like plowing the field, etc., which brought all the dust along with it. So the temples all were situated and the idols were situated much below the level so that the temple is clean. But it's not the case now. We can see that nowadays the temples are like museums, okay, like Scone temple, which you can see, it's looking like a museum. So opening of slippers before temple is an example of custom. Similarly, opening of slippers when we go to another house to greet somebody is also a custom. And third example we can take of like greeting people on festivals. So whenever we go to meet somebody or greet somebody on the occasion of festival, we go with a box of sweets and we go so as to greet them. So this has also become a custom that you should take a box of sweets along with you when you go to greet somebody in a festive occasion. So these are some examples which we can see related to customs. So now let's switch on to the essentials of customs. So the essentials of customs. So if a habit is only of 1 year or of 2 years, do you think it will become a custom, or there is some specific period for which it has to be followed to become a custom? The answer is that there is a period, there is need of a specific period, not exact number of years, but the long period to be followed to become a habit, to become a custom. So, essentials of customs. First, antiquity. It should be followed for a very long period of time. Antiquity means, for example, let us assume that a custom is there, which a habit is there, which is followed by a family in 1910, and the similar habit is being followed in 2020, in 1950. So, do you think it is a custom? That habit has become a custom? Yes, because it has been followed for approximately 110 years, which is a very long period of time to declare it as a custom. So, the essentials of customs. First, antiquity, followed for a very long period of time. Certainty, does not keep changing. The custom does not keep on changing. Like, for example, in a family, A is the head of the family, B is the wife of the head. It's generation 1. And in generation 2, A1 is the head of family and B1 is the wife. So let us assume that in generation 1, A, which is the head of the family, makes a habit of doing doing Z thing in a particular way. Okay, but in the next generation, means his son's generation, the son of A, that is A1, puts another clause in Z habit. Puts a clause Z1, adds a clause. So do you think this will be regarded as a valid custom? No, because the custom or the habit, for a habit to become a custom, it should be followed for a long period of time, and also it should be the same in exactly in the same manner as it has been followed through generations or years. So, certainty, it does not keep on changing. Reasonable, the law has to be reasonable. It cannot be abrupt. You might have heard of many customs which you will be thinking, like, how is it possible that in different parts of the country there are many customs which we think are very stupid or abrupt, but they are customs. So, for a custom to be for a habit to become a custom, it should be reasonable. It should not look like it's very stupid. A common prudent man should think that it should be followed and it is reasonable. So, a custom should be reasonable, cannot be abrupt or stupid. Compulsory observance. For a custom, for a habit to become a custom, it should be observed for a very long period of time, but that does not mean that it takes gaps in between. So, let us assume that a habit has been started in 1910 and it continued till 1930. Then, for 5 years, there was a break in that habit, lapse, and it again continued from 1935 to 210. So, do you think that it will be regarded as custom? No, because there should be no break, however little, in the following of a habit to become a custom. So, this is also essential part or essential feature for a habit to become a custom. Consistency, generational or no change. It should be consistent. What I have already told you, that it should not have any breaks. It should be consistent. It should be followed for generations along. It should not be that the first generation has followed, then fifth generation or probably third generation and in that also some people have followed, that's not the case, then it will not be considered custom. So these are the essential conditions for a habit to become a custom. So now we will look into another source, which is a very important source of jurisprudence, which are statutes. So what are statutes? You all have probably be reading about statutes, about law in your classes, in your BLLB classes. Yeah, no? So statutes are something which have articles in it, sections in it, which an interpreter or a student or a jurist analyzes and gives his opinion on. So statutes is equal to legislation. Legislation, what do you mean by legislation? Legislation means making of law, the process of making of law. So legis is law and lation is making. So legislation is making of law. And who will make the law? Of course, the legislators. Maybe it be parliament or state legislature, as the case may be. Okay. Now, statutes or legislation or statutes can be of two types. One is absolute and another is subordinate. As the name suggests, absolute legislation is the supreme legislation. What is the supreme legislation of our country? Yes, you're right, it's constitution. So constitution is the supreme law of the land, which has to be followed by each and every citizen of the country, irrespective of any caste, creed, place of birth, gender, anything. So the absolute legislation example is constitution, whereas the subordinate legislation example can be legislations which you are studying as subjects. Probably you have studied family law, or the laws which are related to family structure, civil jurisprudence, criminal structure, marriage institutions are all under subordinate legislations. So the sources of jurisprudence in statutes can be absolute as well as subordinate. Now, we have studied as statutes as a source of jurisprudence. So, can you give one example of statute in our constitution? Yes, there is a very simple example which we probably all have heard of, Article 21. Article 21 states that no person shall be deprived of his life and personal liberty except according to procedure established by law. So this is a statute. It is a legislation which legislators have made, which have to be interpreted by courts in cases where there is a conflict or there has a case is involved in it. So now let's look on the views on legislation as source of law. So what Bentham and Mill has to say as statutes as source of jurisprudence. So Bentham and Mill says process of law making and law evolved. So what is statute? Statute is something which is now considered as law, but for making of statute there had been a process of making it, conditions which had made that law, and so the definition of law, source of law according to Bentham and Mill is process of making law as well as law evolved. So it has been evolved by the prevailing conditions of the society. Now Holland. What Holland has to say as for statute as a source of jurisprudence. Making of general orders is same as carried by Crown. So you all will have, you all know that before, let us assume 70 years before, we were under British. We were a British colony. So at that time, the Queen, that was Queen Elizabeth, used to give us charters or give us induce us general orders, which the governors of India had to follow. So the charters given by Queen at that time were the law which India as a colony had to follow. Similarly, in now also, the crown here means the state. The state gives us certain orders in the form of law. The legislators give us orders in the form of written law. So for us to follow that, and if we don't follow that, we have certain legal implications for not following that law. So according to Holland, statutes are making of general orders, same as carried by crown. So in modern terms, we can substitute crown by state. Gray. What Gray has to tell for formal utterance of order. So it's not just that we utter order. It should be in a formal way. It should be in a structurized way. It should be in a in levels, so as to we understand why that law has come and who has given us that law, and we should discuss and what and why this law has come. So it's a formal way of utterance of any order which we have to follow as citizens. So it can be order, it can be judgments, it can be judges, convention. So what judges have to say in conventions will also be treated as law because it has followed a formal structure while delivering of judgment by the judges in a convention. Now, what Salmond? What Salmond has to say for rule of law by authority, expression of will by legislature. So we follow law because there is an authority which forms the law, and we are made to follow the law because we have to follow the instructions of the authority. So according to Salmond, it's rule of law by authority. And he has also told that expression of will by legislature. So here authority can be sovereign, can be legislature in the form of parliament or state legislatures. Now we will look into the third source of jurisprudence. We have seen till now customs as source of jurisprudence, statutes as source of jurisprudence, and now we will look into precedents as source of jurisprudence. So precedents, what does it mean? Precedents is what we have decided or what courts and judges have decided earlier. We have to follow that without questioning on the reasonability of that judgment. This is what precedent is. So going back to the decided and following it is precedents. So there are many types of precedents. First is declaratory, second original, third persuasive, fourth absolute authoritative, and fifth conditional authoritative. So what do you mean by all the types of precedents which I have written on the board? Declaratory precedent, as the name suggests, it will declare some essential principles which are laid down in law or statute which we have to follow. For example, let us take an example of Indian Contract Act. So Indian Contract Act lays down some essential principles which the contracting parties have to follow and which are natural principles. So declaratory precedents contain the articles or sections which are already written in the constitution or any law for say family act or marriage, for law for contract, law of contract, etc. So declaratory law precedent is based on just interpretation of articles and sections. So for example, if it is written that the contracting parties have to sign an agreement before executing the contract, so we don't have to interpret, it's written, so it's declared in that part that we have to follow that if we are the contracting parties. So there's nothing as such of interpretation or application of mind or the legal implications that follow. So original. Next we will see the second type of precedent, which is original precedents. Original precedents are creation and application of new rule of law. You all have heard probably of a very landmark case, Vishaka versus State of Rajasthan. Similarly, you might have heard MC Mehta versus Union of India, which is a landmark case in environment law. So, why I'm telling this? Because when these cases were there, so there was some loopholes which were there in law which had to be addressed so that the parties or the petitioner get some remedy. So these loopholes were addressed in these landmark cases, and thus what happened was that some new principles evolved. So this is original jurisdiction. Original precedents are creation and application of new rule of law which has not been there before. So it's totally new. We can take an example, Vishaka case and MC Mehta versus Union of India. Now let's look into persuasive precedent. So persuasive, as the name suggests, that persuasive is something which is suggestive. It's not binding. So how can a precedent not be binding? All the decisions of the courts, of course, are not binding. You know that the decisions taken by lower courts are not binding because it does not have that much authority for make it binding for the whole country. So the decisions made by lower courts or the decisions which are there by the judges in the international conventions are not binding, so they are persuasive in nature. Similarly, law reviews. If somebody has written a review on law according to the prevailing conditions or prevailing social issue which has arisen, so that will not become binding per se. So similarly, law commission's report, these are also reports, these are not binding. For it to become binding, it should be passed by legislature. The law should be passed by legislature, as well as there should be no appeal immediately following that law. So we have looked into declaratory precedents, original precedent, and persuasive precedent. Now the next source of law is absolute authoritative. Absolute authoritative So, what does the name suggest? Absolute authoritative. It means it has some authority. The president has authority and it's absolute. So, it should be followed no matter what happens. So, let us take an example for that. Article 141 of Constitution. What does it state? It states that the Supreme Court cases decisions should be followed by all the lower courts. So it is authoritative, it's absolute nature that it should be followed. It's not that it is okay if we don't follow or if the lower courts don't follow. So it has some authority. That's why this precedent as a source of law has absolute authority. Conditional authoritative. The name only suggests that it's liable to be disregarded in certain cases otherwise binding. For example, set aside in appeal cases and where question of law is involved. So when cases arose, it's possible that there is some appeal which is filed by the party who has to follow the decision of the court and who is not in the getting hands. So he will of course appeal, and not all appeals become precedents. Only those appeals which have some question of law or some evidences which have not taken into account by the previous courts only become the precedents. So, in conditional authoritative, the appeals should have a question of law involved or a new question of law or new interpretation as to the question of law has arisen, which makes it non-binding or conditional authoritative. It's not proper to say non-binding. We can instead say not absolute authoritative, but conditional authoritative. Now, we should look on views of jurists on precedents, like we have looked into the views of jurists as for statutes as sources of jurisprudence. Now, the views of jurists as precedents as sources of jurisprudence. So, what Gray has to tell, it covers everything, rule and subsequent practice. So, a rule, a law is made, but this does not mean that the law is on paper. It should be followed. It should be followed by how it will be followed. It will be followed if it has some legal consequences attached for not following that law. It can be some penalty or punishment as the case may be. So, Gray has to tell that it covers everything, that rule as well as practice. Now what Salmon has to tell? Salmon has to tell that case laws with binding authority are precedents. So you probably know that now what we study in precedents is what exactly Salmon has to tell. So Salmon definition on precedents as source of law is actually what we study nowadays. So Salmon, case laws with binding authority. So case laws means the laws, the cases which have been there in the past with binding authority, which means a certain rule of law, a certain decision which has to be followed by other courts in the similar circumstances and similar facts is what makes it a precedent. Now next, what Bentham? You probably have heard who is Bentham. He is father of jurisprudence or founder of jurisprudence. So Bentham, what Bentham has to say on precedents. Bentham, judge made law. So he has given a definition for precedents as source of law by saying that what judge has made is what is law as a precedent. So here he is not specifically told that which judge. It can be a judge of higher court, or it can be of lower courts, or it can be the judges of international conventions or agreements. It can be judges of law commissions, etc. So all the judges will be included in it. The judgment law is what Bentham has to say on precedents as source of jurisprudence. Austin. Austin considers judicial law to be the source of precedent. Sources of precedent. So who is Austin? Austin is a follower of Bentham ideologies. So both Bentham and Austin belong to the analytical school of jurisprudence. So I have told you earlier that Austin considered that custom as not a valid source of law, because he considered that law should be what it is and it should be followed as it is. It should not be that if it is followed for a long period of time, it will automatically become a law. For it, there has to be some sanction behind it to make it a proper law. So, according to Austin, judicial law, and why I have written here more supremacy, because as Austin has not given importance to custom as a valid source of law, therefore he has given more importance to precedents as source of jurisprudence. So here he has given more supremacy. Important phrases of precedent cases. So a case has three parts: stay decisis, then we have ratio dissentire, then we have obiter dicta. These are the three parts of any case, whether it be of 10 pages long or whether it be 100 pages long. So, stay decisis literally means to stand by the decision. So, who has to stand by the decision? Obviously, the higher court's decision has to be stand by the lower courts, because higher courts have more authority. So, stay decisis means stand by the decision. It means logically that if some higher court has given decision on a particular aspect which has arisen in a case, then the same analogy or same logic does not need to be again reinterpreted and recollected so as to make it a better law, because the decision has been given previously. So that decision, that similar conditions if have arisen, has to be followed similarly in that subsequent case. Now the next important phrase of precedent is ratio dissentire. What do you mean by ratio dissentire? Ratio, what comes in your mind when you hear the word ratio? Ratio means something which has some binding effect. So if in a case law there are some facts which are material facts and there are some facts which are non-material facts, or there are some evidences which actually lead to the conclusion of the judgment, but there are some evidences which don't form a meaning that why they have been put, as to why they have been put. So ratio dissentire is the crux or body which contains material facts and material evidences. So ratio decidendi is the crux or the body which contains essential elements of or objects which are there in the case, which help the judges or the lawyers to arrive at a certain conclusion. Now, what is obiter dicta? It's a very common word. You might have heard obiter dicta. Said by the way. Obiter dicta are the statements or the facts or the evidences which are said by the way, which are not relevant, which are just there because when a case is discussed, when a case or judgment is made, there are many discussions, deliberations which are acted upon in the court. So while discussing, there are certain things which are said by the way, or which are the opinions of the judges in the proceedings, or which are the allegations which lawyers make on other client or other lawyer. So these are just the things which are said by the way, which are not essential. So obiter dicta means by the way. So let us assume, how many judges do you find in a court? Probably 7 or maybe 13. So if 13 judges have to say something on a particular case, let's assume case A, and there are 13 judges. So all the things which those 13 judges have told should not be necessarily be followed, because these are told by the way by the judges. So now let's look into what is stare decisis. Legend, it's a legend term which I have told you earlier, which means to stand by the decision. It comes from a phrase stare decisis et non quita movere, to stand by decision and not disturb the undisturbed. Courts to abide by the principles and stand by decided cases. That doesn't mean that court have to be that the lower courts don't have any say or they don't have to apply their mind. That does not mean that. It's only in the pre-decided which the cases which are landmark cases, not all the cases the lower courts have to follow. So the stare decisis is courts to abide by principles and stand by deciding cases. Ratio decidendi, part of case law which is binding, has binding effect, which I have told you earlier. Principles decided by lower courts, which separates irrelevant facts from material facts. Those statements of facts on which the judgment has been declared is obviously the part of the case law which is considered to be ratio decidendi. Obiter dictum, said by the way, answers on circumstances and gives no general principle laws. It does not give any general principle. It is just said by the way. It's just an opinion. Now, let us look into. So we have studied customs as sources of jurisprudence. We have studied precedents as sources of jurisprudence. Okay, so what we have all studied till now is customs as sources of jurisprudence, precedents as sources of jurisprudence, as well as the most important part, statutes as sources of jurisprudence. Now we will look into personal laws. So they are two types of personal laws. First, we will look into Hindu law, and next, we will look into Muslim law. So, in Hindu law, we have Shrutis and Smritis. So, what do you mean by Shruti? Shruti is what is heard. So, in ancient time, what happened was rishis and munis, they used to chant something, chant versions which we used to listen and which later formed the four Vedas, which are Rigved, Samved, Yajurved, and Atharved. Rigved is what is Rigved? Do you know what contains in Rigved? Rigved. Rigved contains the mantras or the shlokas which the rishis used to chant. So, Rigved contains mantras and or shlokas. Similarly, Samved. What does Samved contains? Samved contains the works of God or the rituals with like prayers. We offer prayers during festivals. We go to worship God. So these are all included in Samved. Next is Yajurved. What is exactly there in Yajurved? It contains incantations. Do you know what are incantations? Incantations. Incantations are the ceremonies which happen when there is a birth of a child or when there is a death in a family. So, Jalva Pujan and all, what you know about the various ceremonies. So, exactly these are the incantations which are held when there is some specific occasion in a family. So, this is contained in Yajurved. Then, what is Atharved? Atharved contains spells which are related to dance or art forms. Art in the sense, in for example, the music and the dance, and all are contained in Atharved. So these are the Vedas which we have studied in Hindu law in Shrutis. Now, what do you mean by Smriti? Smriti is what is remembered and what is written. So there are three Smritis: Manusmriti, Yajnavalkya Smriti, and Narad Smriti. So these Smritis are important according to the exam point of view. So what does Manusmriti contain? Manusmriti was an ancient legal text. So nowadays, as of now, what we have in present is we have IPC, we have CRPC, we have Constitution. So earlier there was only one legal text which used to uh, help in the governance of the country. So it was legal text, but it was very rigid. For example, if a person steals something from a house, it's just a piece of bread, then his hands will be cut. Okay. Similarly, if he steals a bag full of gold coins from other person's house, then also his hand will be cut. So there was no analogy, no logic behind why this law has come and why these punishments have been there. So Manusmriti is the first legal Asian text. Then comes the Narad Smriti. You all have probably heard. What is there in Narad Smriti? There are many offenses like theft, murder. So who looks into that these offenses should not be conducted? So whether there is a law which states that these actions will be considered offenses and this will be the punishment if this offense is committed. For example, we have CPC, we have CRPC, we have these acts so that if any act like crime, if any crime or civil wrong has been committed, then it is punishable. So in IPC we have certain things which are considered as crime. For example, theft is considered crime, murder is considered crime, and we have a procedure so as to punish the person involved in committing this crime. So similarly, Narad Smriti at that time used to have both substantive as well as procedural law. So Narad Smriti contained substantive and procedural law. Then Yajnavalkya Smriti. Yajnavalkya, had you heard this word? I have told you that Manusmriti is what if somebody has committed a crime like theft or murder, then he will be punished. So there's no logic behind it. Why his hands will be cut if he has just stolen a piece of bread? But if we have to go into the logics, then these logics are available in Yajnavalkya Smriti. So Yajnavalkya Smriti contains logical deductions. So the only difference or the main difference between Manu and Yajnavalkya Smriti is that Manusmriti contains, it is very rigid in approach, whereas Yajnavalkya Smriti sees into the judiciousness of the punishment, the judiciousness as to how much punishment should be awarded and whether principles of natural justice are followed in awarding the punishment or not. All these logics are taken into account in Yajnavalkya Smriti. So the three Smritis which we have looked into are Manusmriti, Yajnavalkya Smriti and Narad Smriti. Now let's move to what I have written, Samved, Book of Chant, participation of people in works of God, which I have already told you. Yajurved is the book on rituals, its collection of incantations. Atharved is a book of spells, various arts and sciences. Smriti is what is remembered or what is written. We have three Smritis, Manu Smriti, Narad Smriti, Yajnavalkya Smriti. Manusmriti is ancient legal text, a society constitution like what we have constitution in the modern era. It is not flexible or amendable, not flexible. Narad Smriti is purely juridical. Its entire focus on procedure and substantive law, like how we have IPC, example IPC and CIPC, like how we have in present era. Then Yajnavalkya Smriti, which looks into the judiciousness of the document as well as the punishment which has been awarded, as well as whether principles of natural justice have been followed in awarding this punishment. This legal theories and texts more liberal than Manusmriti focuses on evidence and judiciousness of document and principles of natural justice. Muslim law. Now let's look into the Muslim law as source of jurisprudence. So it's Holy Quran, second is Hadith, third is Ijmas, and fourth is Qiyas. Holy Quran is a sacred document of Muslims. Hadiths are the sayings of prophets. Ijmas are the opinions of companions of Prophet. A prophet used to have companions so that they used to make his propaganda, his followings reach to the common people. So these are the companions opinions which are called as ijmas. Then we have qiyas. Qiyas are the reasoning and analogy as to why the Prophet has told so, and why he has uttered such statement, and why it has to become a law. All the reasoning and analogy related to the teachings and sayings of Prophet is what we call qiyas. Then we have digests and commentaries as source of Muslim law. So Waqt, commentary on Waqt, board, etc. are example of digests and commentaries as source of Muslim law under digest. So this is all what we have studied now in sources of jurisprudence. In next class, we will studying further. We will studying in detail about the various schools of jurisprudence, like analytical school, historical school, philosophical school, sociologist school, realistic school, etc. So, bye everybody, and revise what has been taught to you.